In this video, we will be discussing the Republic Act Number 11057, the Personal Property Security Act, or the
PPSA was signed into law on August 17, 2018, and it took effect on September 7, 2018. The implementing rules and regulations of this law were passed on October 10, 2019. Republic Act Number 11057, or known as the Personal Property Security Act. It is the act that strengthens the secured transactions legal framework in the Philippines. By establishing a unified and modern legal framework for securing obligations with personal property, which shall provide for the creation, perfection, determination of priority, establishment of a centralized notice registry, and enforcement of security interests in personal property, and for other purposes. It is the policy of the state to promote economic activity by increasing access to least cost credit, particularly for micro, small, and medium enterprises or MSMEs. Now, let's proceed to the definition of terms. Number 1 on the list of definitions is the commodity contract. A commodity contract is an agreement to buy or sell a predetermined amount of a commodity at a specific price on a specific date in the future. The requisites are: first, traded on or subject to the rules of a board of trade that has been designated on a contract market for such a contract, or second, traded on a foreign commodity board of trade, exchange, or market, and is carried on the books of a commodity intermediary for a commodity customer. The second term is the control agreement, and under this we have three. First is the control agreement with respect to securities, which is an agreement in writing among the issuer, grantor, and the secured creditor, wherein the issuer agrees to follow instructions from the secured creditor, with respect to the security, of course, without the consent of the grantor. Second is the control agreement with rights to deposit account, which is an agreement in writing among the deposit-taking institution, the grantor, and the secured creditor, wherein the deposit-taking institution agrees to follow instructions from the secured creditor with respect to the payment of the funds credited to the deposit account without the consent of the grantor. And lastly, the control agreement with respect to commodity contracts, in which an agreement in writing among the grantor, the secured creditor, and the intermediary, wherein the commodity intermediary will apply any value distributed on the account of the commodity contract as directed by the secured creditor without the consent of the commodity customer or the grantor. The third term in the list is the grantor, which is defined as: first, the person who grants the security interest in collateral to secure their own obligations or another person. Second, it is also defined as the buyer or other transferee of a collateral that acquires its rights to subject a security interest. And third, a transferor in an outright transfer of accounts receivable. Lastly, the grantor is also a lessee of goods. The fourth term in the list is the non-intermediated securities. It is the securities other than securities credited to a securities account and rights in securities resulting from the credit of securities to a security account. The next term being emphasized is the notice, which is a statement of information that is registered in the registry relating to a security interest or lien. The term includes an initial notice, an amendment notice, and a termination notice. Now, let's define the term proceeds. So, proceeds is any property received upon sale, lease, or other disposition of collateral, or whatever is collected on or distributed with respect to a collateral. Claims arising out of the loss or damage to the collateral, as well as the right to insurance payment or other compensation for loss or damage of the collateral. Next term is the purchase money security interest. It is a security interest in goods taken by the seller to secure the price or by a person who gives value to enable the grantor to acquire the goods to the extent that the credit is used for that purpose. Moreover, the registry is a centralized and nationwide electronic registry established in the Land Registration Authority or LRA, where notice of a security interest and the lien in personal property may be registered. The secured creditor is a person who has a security interest for the purposes of registration and priority only. It includes a buyer of accounts receivable and a lessor of goods under an operating lease for not less than 1 year. Second to the last term in the list is the security interest. It is a property right and collateral that secures payment or other performance of an obligation, regardless of whether the parties have determined it as a security interest and regardless of the type of asset, the status of the grantor or secured creditor, or the nature of the secured obligation, including the right of a buyer of accounts receivable and the lessor under an operating lease for not less than 1 year. Last in the list is the writing, which is for the purpose of this act. It includes electronic records. Under Section 4 of this law, it states that this act shall be applicable to all transactions of any nature that secure an obligation with movable collateral, with the exception of interest in aircrafts subject to Republic Act No. 9497 or the Civil Aviation Authority Act of 2008, and interests in ships subject to Presidential Decree No. 1521 or the Ship Mortgage Decree of 1978.
Chapter 2, Creation of Security in Interest. In this chapter, it outlines the requirements and conditions for establishing a security interest in personal property. Starting off with Section 5, Creation of a Security Interest. In this section, it mentioned how security interest is being created, and it is through security agreement. This agreement must be in writing, which is signed by the parties. It also clarifies that a security agreement can cover future property but subject to a qualification under the law that security interest will only be created or exist when the grantor acquires the rights over that future property or when he gains the power to encumber it. This prevents the secured creditor from having a claim on something the grantor might never obtain because, again, the security interest only attaches when the grantor gains the necessary rights in the property. Section 6, Security Agreement. As mentioned in Section 5 that a security interest is created through security agreement and must be in writing, so this writing can also be contained in one or more writings provided that when you take the writings together, you can establish or show the intention of the parties, as this allows for flexibility in structuring complex transactions. Furthermore, this section also emphasizes the grantor's right to have the agreement and related notices written in Filipino, as it ensures accessibility and promoting inclusivity. Section 7, Description of Collateral. So in a security agreement, there must be a description where it can reasonably identify the subject regardless of whether the description is specific or general. This means a broad description might be acceptable as long as it's clear enough to identify that those are the property referred to. Section 8, Rights to Proceeds and Commingled Funds and Money. The act of selling the collateral does not automatically extinguish the security interest. It just simply shifts the interest to the proceeds. The security interest is limited to the amount of the proceeds immediately before they were commingled. This prevents the secured creditor from claiming more than what was originally received from the sale of the collateral. So the traceability of the proceeds is a key to determining the extent of the security interest in commingled funds. Section 9, Continuity of Security Interest. This section dictates that a security interest in collateral continues to exist even after the collateral is sold, leased, licensed, exchanged, or otherwise disposed of. This principle is crucial for protecting the secured creditor's rights. Section 10, Contractual Limitation on the Creation of a Security Interest. This section aims to provide access to credit by ensuring that grantors can use their accounts receivable as collateral, even if existing contracts try to prevent them from doing so. However, this protection is specifically targeted at accounts receivable generated from the listed contract types, reflecting a policy choice to prioritize this sector's access to credit.
Chapter 3, Perfection of Security Interest. This chapter focuses on when and how a security interest becomes effective against third parties, a critical step for enforcing creditors' rights. Section 11, Perfection of Security Interest. Perfection is the legal recognition of a secured party's interest, essential for protection in case of debtor default or insolvency. Section 12, Means of Perfection. Different types of assets require different methods to achieve legal perfection, offering flexibility to creditors. Section 13, Perfection by Control. Control provides a strong legal grip on financial assets, often preferred for high value or electronic assets. Section 14, Perfection in Proceeds. Protects secured creditors' interests when collateral is sold, ensuring continuity of security interest in its replacement. Section 15, Change in Means of Perfection. Provides flexibility and legal protection during asset transition or recollateralization scenarios. Section 16, Assignment of Security Interest. Ensures transparency and continuity when secured creditors transfer rights common in financial and commercial transactions. In conclusion, understanding and applying these rules is essential for any creditor, legal professional, or financial institution dealing with secured transactions.
Good day everyone! Today we'll dive into a key component of the Secured Transactions Framework under the Personal Property Security Act.
Specifically, the concept of priority. Now, when we talked about priority, we're asking when multiple creditors have competing claims on the same property, who gets paid first?
The basic rules is, priority depends on the time of registration or perfection, not on when the security interest was originally created. This means if two creditors both have interest in the same collateral, it doesn't matter who first entered into the agreement.
What matters is who perfected their interest first. To perfect means to make a security interest legally enforceable against third parties, typically by registration or.
Section 17 establishes the foundation of priority rules. Here's the rule in practice. Imagine lender A enters into a loan with the borrower and secures it with collateral on January 1, but doesn't register it. Lender B does the same on January 10 but registers the interest on January 11. If lender A only registers later,
lender B still gets priority because registration, not creation date, is the deciding factor. This rule protects creditors who act quickly and responsibly in perfecting their security interest.
Section 18 deals with a powerful method of perfection called control, especially over certain types of financial assets like deposit accounts, investment property, or electronic securities. Control is a stronger form of perfection than mere registration. For example, a bank that has a control over a debtor's deposit account, meaning it can directly access or restrict the funds, has priority over any creditor who only registered their interest. Further, if two creditors have control, the earlier control agreement wins. This is crucial in financial markets where speed and certainty are paramount.
Also, if a bank has the right to set off, example, applied deposit balances to unpaid loans, it will take priority even over other security
This section
interests.
addresses security interest in negotiable instruments and negotiable documents of title. such as promissory notes or warehouse receipts. Here, physical possessions of the instrument beats registration. For example, if a creditor physically holds a bearer promissory note, their interest is prioritized even if another creditor has registered a security interest in that note.
Why? Because negotiable instruments are designed to circulate based on possession, so the law respects that tradition.
Section 20 introduces a legally recognized right known as the right of retention. This gives service providers like mechanics, repair shops, or cleaners the right to retain possessions of goods they work on until they get paid, even ahead of registered security interest. But for this to apply, the possession must be lawful and in the ordinary course of business. For instance, a car repair shop can hold onto a customer's vehicle until the bill is paid.
Even if the car is subject to a registered chattel mortgage, this rule balances the interest of small service providers with those of institutional lenders.
Section 21 protects good faith buyers of goods. If someone buys goods in the ordinary course of business without knowledge of a security interest, they generally take it free of the interest, even if there's an imperfect interest. However, if a security interest is perfected through registration, that perfected interest will beat the buyer's claim. For example, if a furniture store sells goods that are used as collateral, the buyer, acting in good faith and
Unaware of any security interest, won't be liable for the debt tied to that furniture, unless the interest was registered and discoverable.
in insolvency situations, the general rule is that secured creditors may lose their priority. Section 22 assures us that a perfect security interest retains its priority even if the debtor becomes insolvent, as long as perfection occurred before insolvency. This provides stability and encourages lenders to continue providing credit. However,
The rules of the Insolvency Law or the Financial Rehabilitation and Insolvency Act or FRIA still apply. So, secured creditors may face delays or restructuring, but their ranking remains intact.
a purchase money security interest or PMSI arises when a lender finances the acquisition of collateral. Think of car loans or financing for equipment. This section gives PMSI super priority but only if strict conditions are met. First, for equipment or consumer goods, the security interest must be registered within 3 days of the debtor receiving the goods. Second, for inventory, intellectual property or livestock, the interest must be perfected before possession, and notice must be given to
Existing secured creditors. If done correctly, a PMSI can defeat even earlier registered security. This encourages lenders to finance purchases without fearing loss of priority.
This provision gives priority to creditors who provide credit for food or medicine for livestock. To get this priority, the creditor must give proper notice to others. This ensures that essential suppliers like feed companies or
Veterinarians can support livestock operations without fearing subordination to other creditors.
sometimes goods that serve as collateral get attached to real property, combined with other goods or used in manufacturing. Section 25 says a security interest can still survive as long as the collateral is identifiable and traceable. Ownership disputes are settled under the civil code, but creditors still retain their security interest.
This protects lenders who finance machinery, building materials, or bulk goods, ensuring they don't automatically lose rights when the goods are altered or integrated.
Chapter 5 of Republic Act Number 11057, the Personal Property Security Act, focuses on registration and the registry. Section 26, Establishment of Electronic Registry. The Land Registration Authority, or LRA, is a responsible body for setting up and managing the registry. So in simpler words, LRA covers all the registry deeds and provides electronic means for registration. Section 27, Public Record. A. Information contained in a registered notice shall be considered as a public record. B. Any person may search notices registered in the registry. And C. The electronic records of the registry shall be the official records. So in this section, it discusses how all information in the registration deed is something anyone can ask for. So once you have a title, anyone can go to the registry. Any person can inquire or ask information since it is a public record. Section 28, Sufficiency of Notice. This section outlines the requirements for a sufficient notice of security interest to be registered in the registry and the process for handling rejections. First of the requirements is the identification of the grantor, so it must be identified by an identification number. We also have the secured creditor. He must also be identified. Next is the addresses for both the grantor and the secured creditor. The description of the collateral must also be included. And lastly, the arrangement for payment. A notice won't be rejected if it meets that 5 criteria. So it establishes clear and straightforward requirements for registering a security interest, ensuring the completeness and accuracy of the information recorded in the registry. So the prompt notification of rejections and the requirement for grantor authorization aims to protect both the secured creditor and the grantor. Section 29. One notice sufficient for security interests under multiple security agreements. The registration of a single notice may relate to security interests created by the grantor under one or more than one security agreement. So this section tells you that one notice is enough to register more than one security interest. Section 30, Effectiveness of Notice. A. A notice shall be effective at the time it is discoverable on the records of the registry. B. A notice shall be effective for the duration of the term indicated in the notice unless a continuation notice is registered before the term lapses. C. A notice substantially complying with the requirements of this chapter shall be effective unless it is seriously misleading. And D. A notice that may be retrieved in a search of the registry against the correct identifier of the grantor shall be ineffective with respect to that grantor. So these provisions are crucial for maintaining the integrity of the secure transaction system and protecting the rights of both secured creditors and grantors. The rules prevent notices from having indefinite effect and ensure that only accurate and retrievable information is considered legally valid. So from the time that the notice is seen in the registry, then it is already effective. It is already binding and against third persons. Section 31, Seriously Misleading Notice. A notice that does not provide the identification number of the grantor shall be seriously misleading. So this section just emphasizes the importance of accurate and complete information for the proper functioning of the registry. Section 32, Amendment of Notice. A. A notice may be amended by the registration of an amendment notice that 1. It identifies the initial notice by its registration number and 2. Provides new information. B. An amendment notice that adds collateral that is not proceeds must be authorized by the grantor in writing. C. An amendment notice that adds a grantor must be authorized by the added grantor in writing. D. An amendment notice shall be effective only as to each secured creditor who authorizes it. And E. An amendment notice that adds collateral or a grantor shall be effective as to the added collateral or grantor from the date of its registration. So this section describes the process for amending a registered notice of security interest. The provisions the provision ensures that amendments are only effective for authorizing secured creditors and safeguards the interests of each creditor. The specified effective date for added information provides clarity on the legal implications of the amendment. Overall, this section ensures flexibility in updating registered information while maintaining a high degree of accuracy and accountability. Section 33, Continuation of Notice. A. The period of effectiveness of a notice may be continued by registering an amendment notice that identifies the initial notice by its registration number, and B. Continuation of notice may be registered only within 6 months before the expiration of the effective period of the notice. So, this section explains that to extend the validity of a registered notice beyond its initial term, a continuation notice must be filed. Section 34, Termination of Effectiveness of a Notice. This describes the process for terminating the effectiveness of a registered notice of security interest. So what's important in termination of a notice is the authorization of the secured creditor before it would affect his rights. Section 35, Registry Duties. Its duties focus on ensuring the accurate recording, indexing, and retrieval of notices without making any determination on the legal validity of the information contained within those notices. Section 36, Search of Registry Records and Certified Report. So this section explains that when someone searches the registry must provide the existence of elapsed notices, the notice details, and the full notice content. And upon request, the registry will issue a certified report summarizing the search results. Section 37, Disclosure of Information. Section 37 establishes a balance between the secured creditor's need to protect their information and the grantor's right to transparency regarding their obligations and assets under the security interest. The limitation on fees ensures that grantors can reasonably access this crucial information. The exception for deposit accounts protects the privacy and operational integrity of banking institutions. Section 38, Fees set by regulation. A. The fees for registering a notice and for requesting a certified search report shall be set by regulation issued by the DOF for the recovery of reasonable costs of establishing and operating the registry. B. The fee structure or any change thereof under subsection A shall further consider that the same shall not be burdensome to either lender or grantor. C. There shall be no fee for electronic searches of the registry records or for the registration of termination notices. D. The registry may change fees for services not mentioned above. This aims to strike a balance between recovering the costs of running the electronic registry and ensuring accessibility for all users by allowing the Department of Finance or DOF to set fees while considering their impact on both lenders and borrowers, and by waiving fees for certain services. This section promotes the efficient and cost-effective use of the registry. The provision for additional fees allows for flexibility in managing the registry's financial sustainability. The overall goal of this section is to create a functional and accessible system without imposing undue financial burdens on users. Section 39, when the grantor may demand amendment or termination of notice. This section outlines the circumstances under which a grantor can demand that a secured creditor amend or terminate a registered notice of security interest. The grantor can make this demand in writing if the full performance of obligations, partial release of collateral, incorrect collateral description, non-existent security agreement, and extinguished security interest are met. Section 40, Matters that may be required by demand. Section 40 outlines the actions a secured creditor must take upon receiving a grantor's demand for amendment or termination of a registered notice. So this section begins by stating that upon receiving a demand under Section 39, the secured creditor must register an amendment or termination notice within 15 working days. So this section safeguards the grantor's rights and maintains the integrity of the registry by requiring the secured creditor to update the records to reflect the actual status of the secured interest. Section 41, Procedure with Demand. So this section talks about that if the secured creditor doesn't comply with a demand within 15 working days, the grantor can petition the court for an order to amend or terminate the notice. So this provides a legal avenues for the grantor to rectify a situation where the registered information is inaccurate or no longer reflects the reality of the secured obligation. Section 42, Compulsory Amendment or Termination by Court Order. Section 42 provides a crucial mechanism for resolving disputes between grantors and secured creditors regarding the accuracy and continued validity of registered notices. So it empowers the court to rectify inaccurate or improperly maintained registrations, ensuring the integrity of the registry. The right of appeal for the secured creditor balances the grantor's ability to seek redress, while the LRA's obligation to comply promptly ensures the efficient functioning of the system. This section reinforces the legal framework's commitment to fairness and the accurate representation of secured interests. Section 43, No Fee for Compliance for Demand. A secured creditor shall not charge any fee for compliance with a demand received under Section 39. So Section 43, in conjunction with Sections 39 and 40, safeguards the grantor's rights by ensuring that the secured creditor's compliance with a valid demand is not financially burdensome, since Section 43's prohibition on fees ensures that the grantor's right to demand amendment or termination is not hampered by financial barriers. It promotes fairness and prevents the secured creditor from using fees as a deterrent to legitimate requests. Section 44, when registration and search constitutes interference with privacy of individuals. A person who submitted a notice for registration or carried out a search of the registry with a frivolous, malicious, or criminal purpose or intent shall be subject to civil and criminal penalties according to the relevant laws. So Section 44 safeguards the integrity of the registry by establishing legal consequences for those who misuse it for illegitimate purposes. The broad language ensures that a wide range of abusive behaviors are covered, deterring individuals from using the system for anything other than its intended purpose. So this provision of both civil and criminal penalties reinforce the seriousness of such actions and protects the rights of those who legitimately use the registry.
Chapter 6, Enforcement of Security Interests, Secured Creditors' Rights. An overview of the rights and procedures granted to secured creditors upon a debtor's default under the law. Section 45, Right of Redemption. This right protects debtors and third parties by giving them a final opportunity to recover their assets before final disposition. Section 46, Right of higher-ranking secured creditor to take over enforcement. This ensures that priority interests are respected and more secured creditors can assert control to protect their stake. Section 47, Expedited Repossession of the collateral. Balancing quick enforcement with protection against breach of peace and undue force. Section 48, Recovery in special cases. Allow secured creditors to act swiftly and efficiently in limited, special circumstances, post-default. Section 49, Right to dispose of collateral. This gives creditors flexibility in recovering value from the collateral while adhering to market standards. Section 50. Commercial reasonableness required. This prevents abusive practices and ensures fairness in handling and selling collateral. Section 51. Notification of disposition. This guarantees transparency and provides time for objection or redemption. Section 52. Application of proceeds. Ensures proper distribution and accountability of proceeds. Section 53. Rights of buyers and other third parties. Encourages market trust and fairness for innocent third parties. Section 54. Retention of collateral by secured creditor. This alternative to sale but must ensure notice and consent to protect stakeholders. In conclusion, the chapter reinforces balance between efficient creditors' recovery and fair debtor treatment.
Transitional provisions, the requisites are the following: existing secured creditor, prior law, prior interest, and transitional period. First is the existing secured creditor. It means a secured creditor with a prior security interest. Next is prior law. It means any law that existed or was in the force before the effectiveness of this act. Third is the prior interest. Means a security interest created or provided for by an agreement or other transaction that was made or entered into before the effectivity of this act and that had not been terminated before the effectiveness of this act. But it excludes a security interest that is renewed or extended by a security agreement or other transaction made or entered into on or after the effectivity of this act. The transitional period means the period from the date of effectivity of this act until the date when the registry has been established and operational. Next is the creation of prior interest, and it shall be determined by prior laws. Also, a prior interest remains effective between the parties, notwithstanding that this creation did not comply with the creation requirements of this act. As to perfection, perfection will continue until either it ceases under the prior law or until full implementation of the PPSA. So basically, whichever comes first or earlier, then it is perfected. When it comes to priority, this is determined by prior law if the security interests and the rights of competing claimants arose before the PPSA and the priority status has not been changed since the effectiveness of the PPSA. We will know that the priority status has been changed if first, the perfection took place when the PPSA took effect, but it ceased to become perfect. Or second, if it was not perfected before the PPSA, but become perfected after the PPSA took place. Now, for enforcement, if any step or action for enforcement was taken before the effectiveness of the act, then there is a choice. First, enforcement can be done either under the prior law or under the PPSA, except if the enforcement is subject to the court proceedings. Then, necessarily, we have to follow the prior laws.
Let's now move on to Chapter 8, beginning with Section 60, which establishes congressional oversight. The law recognized that financial and legal system evolve, so to keep the Personal Property Security Act relevant and effective, an oversight committee is created. This committee will include the chairs of the Senate and House committees on banks, financial institutions, and currencies. Their task is to review the implementation and impact of the law every 5 years from the date it takes effect. Such periodic review ensures the
law keeps pace with technological changes like digital registries, market needs, and enforcement realities. It adds accountability and adaptability to the legislative framework.
Section 61 provides a guiding principle for legal interpretation. It states that this act shall prevail in case of any conflict with other laws, unless another law explicitly states otherwise. Why is this important? Because the law aims to unify and modernize the rules on security interest in personal property. If older or general laws like the Civil Code or chattel mortgage law conflict with the provisions of this act, this law takes precedence. This ensures clarity
And removes legal confusion. It's what we call a governing clause.
Section 62 tasks specific government agencies with developing the implementing rules and regulations or IRR. Specifically, the Department of Finance or DOF and the Department of Justice DOJ through the Land Registration Authority or LRA must jointly issue the IRR within 6 months from the law's effectivity. These IRRs are crucial. They contain the technical details and procedures to operationalize the law. Without them, the law is just a broad framework. The IRR covers registration
Procedures, technical registry design, enforcement protocols, and more. This ensures that stakeholders, from banks to small businesses, know exactly how to comply.
Section 63 emphasizes that enforcement of security interests should be done through summary proceedings. This means the legal process should be fast, simple, and efficient. Unlike regular court trials that can drag on for months or years, also, enforcement must follow the rules laid down by the Supreme Court and must align with the declared policy of the Act, which is to promote access to credit and economic growth. This section is key because even a well-structured secured transaction is
Useless if enforcement is too costly or time-consuming. Quick enforcement builds creditor confidence and improves the credit ecosystem.
Section 64 deals with budgetary implementation. It says that no new budget is needed to implement this law. Instead, funding will be drawn from a special account, specifically from revenues of the LRA. This is important because it eliminates financial delays and shows the law is designated to be self-sustaining. In effect, this ensures
The government can roll out the registry and related infrastructure without waiting for annual budget appropriations.
Section 65 contains a standard but crucial legal safeguard, the separability clause. If any part of the law is declared unconstitutional or invalid, the rest of the law remains in full force and effect. This protects the integrity of the law and ensures
that a single flawed provisions doesn't bring down the entire act. For example, if a court strikes down a specific rule on registered deadlines, all other parts including creditor rights and enforcement procedures remain intact.
Section 66 is a repealing clause that clears the way for this new framework by repealing or amending conflicting provisions in older laws. These include the Chattel Mortgage Law Act No. 1508, relevant parts
Of the Civil Code, the Financing Company Act, the Property Registration Decree, parts of the Land Transportation and Traffic Code. This ensures that the legal system is not burdened by conflicting or outdated rules. It represents a legal modernization of personal property securities law.
Section 67 is the effectivity clause, which states that the act will take effect 15 days after its publication in at least 2 newspapers of general circulation. This is standard for national laws and ensures
The public is notified before the law becomes enforceable. It balances transparency with enforcement and gives stakeholders time to prepare.
Finally, Section 68 adds a conditional clause for implementation. The law becomes operational only once the electronic registry system is established and fully functional. These provisions reflects practical wisdom. because the registry is the backbone of this law. Without it,
The law cannot operate effectively. It underscores the principle that legal reform must be matched by infrastructure readiness, especially in tech-driven laws.